Episode 128, Meta wins AI copyright case.
The primitive forms of artificial intelligence we already have proved very useful.
AI is a golden opportunity.
How do we ensure that this technology is regulated?
The long arc of technological history is now in an extraordinary new phase.
The AI6 podcast with Joanne Sweeney.
Is it legal for AI companies to train their models on books, songs, or articles without asking artists' permission? Well, this is a question I've tried to answer previously on this podcast. But I'm revisiting it again because a new court ruling in the US just gave us a big clue, and it's one that content creators need to know about, including myself. Hello and welcome back to the AI6 podcast. I'm Joanne Sweeney and I started this podcast to help you accelerate your AI knowledge, skills and confidence in just 6 minutes a day. So what's the story? The lawsuit Kadrey versus Meta ended last week in the US. This is a lawsuit where 13 authors, including big names like Sarah Silverman and Ta-Nehisi Coates, took Meta to court, claiming the company used their books without permission to train AI models. The author said Meta scraped their copyrighted books from online sites and fed them into its AI systems, all without paying or asking. They claimed this was copyright infringement and that it hurt their ability to earn from their work. But here's where it gets interesting. The judge, Vince Chabria, wasn't convinced. He said the authors couldn't show real harm. Could they prove that Meta's AI was spitting out content that actually competed with their books? Not really. And while the authors focused on the piracy side, how the books were obtained, the judge said the real issue was whether Meta's use counted as copyright infringement under US law. Meta argued that using the books to train AI was fair use, a legal concept that allows copyrighted content to be used without permission in some cases, like research or creating something new. The judge seemed open to that, especially since there was no clear evidence that it hurt book sales. In the end, the judge dismissed the case. He said the authors made the wrong arguments and didn't provide enough proof of harm. But he also made it clear this ruling only applies to this group of authors. Another case with stronger evidence could go differently. So what does this mean for creators and AI? In the US, courts are leaning towards allowing AI training under fair use, as long as there's no obvious damage to the market for the original work. But in Europe, the rules are stricter. Creators can opt out of having their work used for AI training, and developers have to be transparent about what data they use. So the result, it's a divided legal landscape. And as I said in the previous episode around this topic, we need more legal precedent in order to better understand where creators and where AI large language model companies lie. AI developers might find the US more flexible for now, but they'll have to follow much tighter rules in the EU. And so the next question I wanted to pose in researching this podcast episode was, have there been any such cases in the EU? As an EU-based author, I'm curious as to how this stacks up under our copyright laws. But part of me believes it's a horse-bolted moment. The models are already trained. AI is bigger than us. Sad, I know. But here's the situation in the US. So, Like Company versus Google is an EU-wide case. The issue and the case states that AI training and outputs affected copyright. It has been referred to the European Courts of Justice and is pending a decision. There's also a German case. Actually, there's two, and there's one in France against Meta, and there's one in the Czech Republic. But the most potentially impactful case for the EU's AI and copyright landscape is Like Company versus Google Ireland. It's currently before the Court of Justice of the European Union. In this case, Hungarian news publisher Like Company alleges that Google's AI chatbot Gemini reproduced and made available substantial parts of its protected news articles without consent, arguing both the training and outputs of large language models, or LLMs, constitute copyright infringement. The CJEU is being asked to clarify whether LLMs on copyrighted content and their resulting outputs amounts to acts of reproduction or communication to the public under EU law, and whether the text and data mining exception applies to such practices. The court's ruling will set a crucial precedent for how AI developers and publishers must navigate copyright compliance and the scope of rights in the digital age. Meanwhile, back in the US, Kadrey versus Meta is a win for AI developers in the US for now. But if you're a creator or working in marketing, publishing or media, don't switch off. The legal debate is far from over, and in Europe, the tide might be turning the other way. I, my friends, have invited a number of legal experts to join me on the long listen of the AI6 podcast to discuss this in more detail, so hopefully I will have them on air soon. I'm Joanne Sweeney. This is the AI6 podcast. I'll talk to you tomorrow.